Hi, welcome to another episode of the South Texas Power Lunch. I'm Matt Duke, managing attorney for the South Texas Business Lawyers. And today is a real treat because I got to interview my mentor, Jeff Gifford, who is with Dykema here in San Antonio. I'm talking about mergers and acquisitions, or M&A, all things M&A. It's a real treat because it's where I started my career here 16 years ago. And this episode is great because we talk about the state of M&A, the future of M&A, which what we think we'll see in 2025, including Dykema's assessment that they just put out a couple of weeks ago about the state of M&A in 2025. But it's a great episode for you if you are thinking about selling or acquiring a business, of the things you need to know about, some things that could become trouble for you. It's just really a good education on M&A for those that don't do it every day. So with that, let's get into the episode. Jeff, thanks so much for coming here on the podcast. I'm glad that we could finally get you on here.
Thank you. It's my pleasure to be here.
So, disclosure to everybody that's watching here, Jeff is one of my mentors in life and when I was a baby lawyer here over at Cox Smith, which is now Dykema. And, you have influenced all sorts of my career. So I'm going to start off by just saying thank you for all of that, because there's a lot more that, I could say about all of it. I'm just going to simplify it with just thanking you from the beginning, from coming on and just being a great mentor.
Well, you are certainly welcome. I think you're giving me more credit than I deserve, but you've been a good friend for a long time. So happy to be here.
Well, when I mess up, I blame it on myself. When I do it right, I'm like, because Jeff Gifford and others, Steve Elder, Will Lehman, the people that have mentored me, they're the ones that taught me right. And so, mentors, I would say for those that are lawyers out there, especially on the transactional side, the mentor side is huge.
Yeah, it's huge. Different, right? The transactional practice, you learn how to think analytically and critically and logically and those things in law school, right? They teach you some of those skills, but when you actually start practicing law, it's a steep learning curve those first several years for transactional lawyers, because a lot of what you're learning is very different from the education you get in law school.
That's right.
It's a very practical education.
Yes. It would be great if they could figure out how to do a little bit more of that practical education in law school, but that's
from what I hear, it's swinging that way, but I haven't been there for a long time, so I don't know.
No one would believe how old you are, Jeff. You're young. They would think you're just recently out of it. So let's talk about mergers and acquisitions, because here on our podcast we talk a lot about startups and founders and, those sort of things. Right. But we, here I do still about half of my work is mergers and acquisitions, more acquisitions and divestitures. But people don't really, most small, medium-sized business owners, this is completely foreign to them because they know how to operate their business, they run that business, but when it comes to exit it or they want to buy a business, this is new territory for them usually.
Yeah, so it's a fascinating world. Obviously, it's the world that I live in. A great deal of my time is spent in the M&A world, and I enjoy it a lot, doing deals, doing transactions, whether it's M&A work or public and private securities offerings. Large transactions are a lot of fun. But in my personal career, right, I've had the pleasure of representing, yes, multi-billion-dollar, international companies, but we do a lot of work for mom and pops too, who really rely on, our advice, good advice, to get them where they need to be. So, yeah, there are lots of advantages to M&A, as you know, right? There's growth strategy to M&A. There's exit strategies for people who are looking to get out and, pass on a business to somebody else. So lots of reasons to understand M&A and to be prepared for it before it happens.
Yeah.
That's the real key.
That's huge. I can't tell you how many people realize they call, I'm sure you get it too, even in your world, maybe not in the billion-dollar ones. Hey, I got this deal. Can we close it next week?
Yeah.
Yeah. This is not a house.
Yeah. No. Often to your point, Matt, a lot of times you'll get clients be like, hey, well, I'm going to negotiate all this stuff in the front end, and then I'll come talk to you after I have a letter of intent in hand. Well, too often people give away so much in those letters of intent. Involve your lawyer early on before you get to the letter of intent, because there's leverage that can be exercised in that letter of intent. I've had clients come to me say, oh yeah, we've got this fully baked deal, right? Essentially, just need you to document, right? We'd like to close in a week or two. And here's the letter of intent. They prepared it, and I look at it and I'm handcuffed now because they've given away so many leverage points already in the letter of intent before we even have the deal documents in hand.
And, the letter of intent for those, that may be not too much experience with it, that's kind of the beginning conversation where you're putting together the business points of it.
Principal terms, yeah.
They really, I mean, especially in my clients that I deal with that are, in the lower middle market, they just view it as, well, I got the business points on there. But if you don't understand the legal aspects with your strategy for what you're trying to do, then those business aspects may actually be misguided.
Yeah, that's right. Or just things that you're not thinking about, right? That's why you hire lawyers, is to think about the legal aspects and the risk allocation as opposed to just the business points. And
right.
So things like, indemnities and reps and warranties and covenants. And I'm sure we'll get into all of that. But.
Yeah, no, I mean, we'll get into some of that because, we could have a complete,
we could have a separate podcast
seminar on this, put on it. But,
right.
Let's stay on this though, because the beginning really for someone that's thinking about buying or selling it is to come to some sort of agreement on terms. And I'm sure you run into this too. It's it's not binding. So I'm just going to go ahead and negotiate all this and put this down. But
sure.
What people don't realize, and I'm sure you've had these experiences too, when the lawyer comes on the scene and goes, yeah, that's not probably smart to do that. When you try to go back to change a deal that's already been memorialized, even in a non-binding manner, it's like turning the Titanic around for most of those situations.
It is. Well, and first of all, it's a little bit of a misnomer, right, for folks who aren't familiar with the M&A world. When people talk about non-binding letters of intent, there are actually binding provisions that are in a non-binding letter of intent. Right. So while several of the provisions are not binding, right, there are some that are binding, and those certainly need to be negotiated. But even on the non-binding terms, right, yes, some business people say, well, it's non-binding, that we were just having discussions. The problem is you've sort of set that in a soft cement, right? People have expectations. There's almost like this moral obligation that goes along with those non-binding terms, because people are willing to move forward on looking at more binding documents or more permanent deal based upon this soft-ish, right, understanding. And if you move beyond the letter of intent into, say, a diligence phase before you get to deal documents, or even straight into deal documents, and you're now going back and trying to renegotiate those non-binding terms, you can cause harm in the negotiation process, because people start to, trust becomes an issue, good faith becomes an issue. And so people should not take lightly the non-binding nature of non-binding letters of intent.
Yeah, I mean, For I want to distinguish that just a little bit. Is a lot of the times they realize you're not getting a lawyer early enough, right?
Yeah.
It's usually there's been no change of circumstance. There was just a lack of knowledge. A lot of first-time buyers and sellers of businesses. Then when they get that knowledge and try to do it, it's soft concrete. That's a good one. I would say it's still wet concrete, but it's pretty much dry at that point in time. Right? Versus new information that you get, which can then change, a deal structure with things that you didn't know through that diligence phase. But I'm gonna have to use that one, soft concrete, because that's what it feels like for the lawyer trying to get it out when when you're trying to, a deal
the mixed
team,
cement has started to set.
That's right.
That's what,
That's right. Let me back up just a little bit. Sure. And, I'm gonna kind of shoot all over the place just, to get people that I know would really like to hear your thoughts on it. Acquisition of assets versus stock. Many people in the lower middle market, which let me kind of stay in that market. I know because it changes, a lot with some strategies as you move higher into the market value. But for the lower middle market part, I have a lot of people that come to me buying businesses saying, well, I'm just gonna buy the stock.
Yeah.
Versus what we do a lot on that market is doing the asset sales. What is your opinion on, asset versus on stock just in general?
Well, it depends if I'm representing the buyer or the seller, but
I'll let you pick whichever one you want to.
So the advantages and disadvantages of both, right? So, for when you do a stock deal, right? And I'm going to provide probably an overly simplistic analogy.
Well, that's fine.
Think of a company as a bucket, right?
Okay.
You got a bucket, and inside that bucket is all the stuff. The assets, the intellectual property, the employees, all those things are inside of the bucket. So the bucket is the company. In a stock deal, what's happening is the buyer and seller are agreeing that the seller is literally just going to hand the bucket over, right, to the buyer. Seller's going to hand the bucket over to the buyer. So the buyer is going to get whatever's in that bucket. There are ways through due diligence, right, for a buyer to really do all he or she can to explore the nether reaches of that bucket and understand.
Is there a film on the bottom of the bucket?
Yeah, exactly. What am I really getting in that bucket, right? Because when you get the bucket, you get the bucket. You get everything that's in the bucket, the good and the bad. So whatever's in there is in there, right? Whereas typically a buyer, not always, but more often will want to do an asset deal. Because in an asset deal, the buyer comes in and they look inside the bucket and they say, okay, look, I want substantially most of what's in that bucket. So I'm going to take these assets out and these assets out and these assets out. And I'll agree to assume, these liabilities and these liabilities because they're related to the assets that I'm pulling out of the bucket.
Right.
But there's other stuff in there that I don't like, or there might be stuff in there that I just can't see. The bucket's too big, or,
Sure.
or the deal is going so fast we don't have time to explore the whole bucket.
Right.
Buckets can vary in size. And so the buyers often prefer asset deals because it allows them to pick and choose what it is they're really interested in, what they want to pay for. And if it turns out that the seller, through years of operation, on purpose or not on purpose, has something in their bucket that the buyer doesn't want, and it crops up after the deal is done, well, it's not going to be the buyer's responsibility. It's going to be the seller's responsibility because they still own the bucket. The bucket's still there and whatever's left over in it. So so buyers tend to prefer asset deals, not always, but usually they prefer, and sellers tend to prefer, stock deals because stock deals are a little bit simpler typically from a documentation standpoint. And the seller, right, who's just a shareholder is basically saying, or a membership interest owner in LLC or whatever, they're just selling the equity. So they're saying, like, here's my certificate,
right,
that shows that you now own the bucket, and that's
right.
And that's it. Now there's still a lot of detail that goes into the purchase documents. There are also some other advantages, right? Like typically tax can play a big part in this. More often than not, there are more advantageous tax consequences to doing a stock deal than doing an asset deal, although there are sometimes elections that you can make into the tax code that can ease that burden on the seller. Buyers, again, typically from a tax perspective, like asset deals because it allows them to specifically allocate, basis to various assets and things as, for the purchase price that they've paid. So those kind of at a high level is distinctions between.
No, the bucket's a great analogy. I always tell people, the analogy I use is, if you're gonna, if you buy it on a stock deal, any sins of the past and ghosts of the past will haunt you.
Yeah, that's right. That film in the bucket you were mentioning. If it's in there, it's in there.
If you're okay with a ghost or, and again, the risk levels vary based upon whatever industry or operation they're in. I'm like, if you're okay with that, we can talk about that. But I mean, I've rarely found in that market where somebody goes, well, that's acceptable, that I'll just let these ghosts in the past, come after us. Let me move into diligence because, a lot of people, when they can Google things or chat GPT now, which we'll get into AI in the future of that, it's not going to replace transactional lawyers. Sorry. Good luck with that.
Yeah.
But as you move through the process of it, people are comfortable with diligence for companies they're going to buy or sell on the financial side. Because that's where like, oh, okay, let me just do my financials.
Right.
But what they miss many, many times until they get with someone that does M&A, walks through, risk allocation and how we need to identify things and those sort of things, then they start to realize the value of broader diligence outside of just the financials. Financials are super important.
Right.
Usually that's the financial reason that you've come to this because you want to make money. It's the reason everybody's sitting at the table because it's going to change hands.
Right.
But the risk of that money, like who really gets to keep it for how long or what you really get for value is all in the diligence. What do you tell, first time buyers or sellers about the diligence process? How do you set that up for them?
Yeah. So two different processes, honestly. So let me talk about the sell side first, and then I'll talk about the buy side. If I have a seller who's thinking about selling their business, I will often tell them, look, you really want to start thinking about that a good 6 to 12 months before you actually, quote unquote, start in the sales process itself. And the reason for that is the buyer is going to come in with a due diligence request list if they're a sophisticated buyer, and they're going to want to turn over every stone in the company. And so the best thing that a seller can do is start that process again 6-12 months earlier, so that they can be thinking about, okay, what's the buyer going to want to see? And I'm going to use the word clean up, right? But they can clean up, or the words clean up, they can clean up their records, things that are in their business, right? Oh, I know we've got a contract with those folks. Can we pull that from the file and make sure that we have all the signatures on it that we're supposed to, right? So they prep themselves. It's like selling your house, right? Like when you go to sell your house,
you're going to get
you clean the carpets, you wash the windows, you bake fresh cookies before folks come in the house. It's the same kind of thing when you're selling your business, right? You go make sure your records are tight, everything looks good. You also have the opportunity to identify, certain issues especially with small family home or small family owned businesses. They'll sometimes run things through the company that won't any longer be run through the company when the buyer comes in, right? So you take those things out and it can actually make the financials look even better, right? When the company car that's being used by the family is no longer being paid for by the company, the financials look better for the end.
It's a great analogy there about the house, because, think about if you had a hole in the wall, like drywall, right?
Got to patch
It's not gonna stop the value. I mean, it's not a big deal, right? But you're gonna make sure that hole is patched before somebody comes in. Because if somebody comes in and sees that hole, they're gonna go, well, what else is in this house that I need to deal with?
Right.
It's the same thing.
Yep.
Some of the stuff, most of the things like that, right? Like, okay, let's get all the contracts and signatures. Let's get the corporate docs cleaned up. They could be done while someone's looking at your business.
Yeah.
But that's a signal to them of potential sloppiness. And
it's all about impressions
out there that could actually change, the risk thresholds in a negotiation if you're not on there.
That's exactly right.
And so it's something that, a lot of times, and even when I was a young baby attorney, I had to go and chase all those signatures and get some of those things up. And it's never perfect, but the more proactive you can be, the easier process and it can be for that.
No, you clean up your corporate records. You make sure you have copies of all your contracts. You go back through, your benefit plan information, employment contracts, making sure you have. There's a million things that go into the diligence process, right? But that's why you work with an attorney, an M&A attorney, because they can say, look, this is the list or something similar to this that the buyer is going to present to you.
Right.
And I can help you as a business owner prepare all these things ahead of time so that when somebody comes in, a buyer comes in, they, wow, this seller is organized. They've got the answers to all my questions right at their fingertips. They've really run this thing, really well. They've taken the time to think about this. They're careful. They're thoughtful. My trust level as a buyer goes way up.
Right.
The easier the diligence process is, right?
And your legal bill goes down too, the easier the diligence process.
Yeah, that's right. Because
because you don't have that baby attorney that's chasing around and trying to find all of that stuff, as well.
Yeah, exactly. So for the seller, again, 6 to 12 months beforehand is when and then, as you start talking with people, you make sure you have a confidentiality agreement in place that says, hey, if I'm going to give you a peek under the hood, right, of my business, I need to know that you're not going to use it or disclose it to anybody else. So you negotiate those things roughly around the same time as maybe a letter of intent. Sometimes the confidentiality agreements come first for some initial information, and then the letter of intent comes after, and then you eventually move to deal documents. For a buyer, it's not quite the same thing. Most buyers, I shouldn't say most, it's often the case that buyers who are buyers have been buyers before, right? It's not their first rodeo, and so they've been through the process, so they understand it a little bit more. So they'll initially, have a confidentiality agreement where they'll be willing to go in and say, yeah, I want to look. Financials is almost always the first thing.
Sure.
Right? Like, hey, I want to see your last balance sheet, your quarterlies. I want to get an idea of what the revenue aspects of the company and the liability aspects of the company are. And then when they move beyond that, then it's making sure, right? For now if I'm representing the buyer, it's, look, now we want to make sure we turn over every stone, right? We're going to ask a list of hundreds of questions to make sure that we're getting answers from the seller about, what kinds of benefit plans do you have? We want copies of all the benefit plans. Have they been properly, administered since you've had them? Tell us about all your employees. Tell us about your insurance claims. Tell us. So, we're going to do a deep dive. And as the buyer's counsel, right, the more answers I get from seller, like, well, I don't know, we just operate a business, right? Like, your lawyers, he's worried about all this stuff.
I signed some piece of paper maybe 3 years ago, but they always pay on time, and it's a great relationship.
Right. So, those are, potential red flags that,
Sure.
that we as buyer's counsel would, talk to the buyer about and just say, hey, look, these folks ran this operation loosey-goosey. That should tell you something about the risk level you're taking on, right? And whether or not you want to do a stock deal or an asset deal or not do a deal at all.
Right.
We try really hard not to be deal killers. I mean, over the 25 years that I've practiced, people want to do the deal and we want to help them do the deal. There have been less than a handful of times in the hundreds of deals that I've done where I've felt like I needed to go to the client and say, hey, look, based upon the due diligence of the stuff I'm seeing, I'm not the business guy. You are, but I would not do this deal.
Right.
That has happened so rarely, but it does happen occasionally.
I always tell, and I learned this from my mentors, including you, we're here to quantify, detail the risk, try to recommend where you can alter the risk. But at the end of the day, look, the client's the boss.
Yeah,
I've had some clients that I'm like, I think this is issue. And usually what I say is, I always say flags, right? I've got a flag. I'm not sure what it is because we got to figure out what it is. A yellow flag's not great, but it's not the end of the world. A red flag, hey, this is a big deal. I was like, and then we have the one where I've got 2 flags and I'm going to jump up and down screaming, whoa, 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 whoa. Yeah. You still want to do the deal after I scream that? Yeah. Okay, I'll send you an email saying how I was just screaming those flags. Let's do the deal, and that's what the value of good counsel.
It's all about risk tolerance.
Yeah, right. is being able to quantify it, identify it, quantify it, make recommendations, and then help the decision maker make that decision. Because sometimes, I'm sure you had this too. You may look at a deal and go, well, that's kind of a dog. But when they tell you, well, in our strategy, we're going to take this dog and put it over here, and now it's going to be a great,
Yeah, the business team knows things that I don't as an attorney, right? And attorneys by nature are considered, to have a conservative risk profile. I think that's a little less true of some of us who have been in the M&A world for a long time because we understand, based upon prior experience, how much risk is really risk and what business. But every client's risk tolerance level is different, and some are willing to jump and then ask questions later, and but many ask the questions up front and then jump, which is really the more prudent approach.
So as part of that risk, and this is a conversation again, and kind of talking again to the people that this is their first, maybe second time.
Yeah.
When we talk about risk allocation and they go, well, wait a minute, I'm doing an asset deal. I'm just getting the assets out of this. Why do I need representations, which I always say are statements of truth, that we're saying we're relying upon these statements of truth? Well, what do I need that for? Because I'm just going to get the assets for what they are. If there's anything out there to the bucket, right?
Yeah.
Why do I need them to still rep about how the bucket is clean on the bottom when what do I care about? How do you respond to that?
No, it's a good question. And, again, it varies, right? And in the simplest of deals, sometimes I can tell a buyer, well, you don't have to worry about that because in a super, super rare circumstance, all you did was literally buy an asset on, and that was it. And said, I'm not taking anything else. I'm just taking these assets. And
I'm taking all these cranes.
I'm taking all the good stuff. Right.
And you got everything else.
Yeah, exactly. So in that case, I was like, you really don't have anything to worry about because your deal was so specific to these particular assets that there isn't anything. However, that's not usually the case.
Right.
Right. So often they'll say, well, why do I need to worry about this? And the answer is, well, because as hard as you might try, and as hard as we might try as lawyers to identify what's being taken and what's not being taken, it could turn out that what's being taken is not exactly what we thought it was.
That's right.
Right? There might be a hidden liability in the liabilities that were assumed.
Right.
That is suddenly a problem.
That's right.
Right? And so I say to the buyer, in that case, you want to be able to have recourse, right? You want to be able to say, hey, look, when I bought this, I thought it was worth, just making up a number, 10 million, 50 million, I thought it was worth $50 million. But because of this extra liability that I didn't foresee, and maybe the seller didn't either.
Right. I mean, many times they just didn't know.
It could have just, it could have just been hidden or accidental or unknown at the time. But if the liability was something that occurred out of the operations before the buyer bought it, from a risk allocation standpoint, right? Typically you would say, well, that's only fair that the seller should have to.
Because I didn't own the business.
I didn't own the business then, and I wasn't intending to take on that liability. And so we provide for in the contracts the ability for the buyer to be able to go back to the seller and say, hey, this wasn't, neither of us saw this, but it was never an intention that I take this. We agreed that that kind of a risk would be allocated to you. Therefore, I need to claw back, right? Either you hand me back over money I've already paid you, or maybe I have, and maybe there's an escrow that I get to pull against. Nowadays there's reps and warranties insurance. That's a whole different podcast, probably topic.
That is,
that we could get into that could help, protect a buyer. But that's why the answer is for unknowns.
Yeah,
right?
and
it's for unknowns.
And you can't,
or it could be known things, but we're not exactly sure how they're going to turn out.
Right.
So you identified the issue, and now you just have to deal with the consequences of the issue.
Yeah, I mean, for a lot of people, they don't realize is if you don't. I mean, there is there's a structure to M&A, that is pretty well, I mean, it's very well established, right? I tell people, look, I mean, some of these documents to do a deal, 10, 15 pages, for the smallest of deals,
sure.
I've been of them where there's thousands,
yeah.
thousands of pages, right? It's risk tolerance and those sort of things. But if you don't get the right paper in place to do risk allocation with recourse, then I can't tell you how many times, I mean, we have a lot of people will call and say, hey, I bought a business. I didn't know A, B, C, and D.
Yeah.
Okay. Well, did you paper that? Well, yeah, we got a bill of sale off of LegalZoom, and I got the assets.
Yeah.
Well, congratulations. Not much recourse there.
Yeah. You just bought the liability.
Yeah.
Well, and that's, and people, I know, some people get annoyed with lawyers, right? Because they're super hyper focused on the details. But, on the opposite end of that, what I often will tell folks is, hey, look, I have seen case law come down that has literally turned on the absence of a comma, right? Like a multi-million-dollar judgment went in favor of the seller instead of the buyer because of the failure to place a comma in a sentence on a document.
I have a comma case right now, actually.
Yeah. So,
and I'm like, there's no comma there.
Yeah.
So it doesn't.
Right.
Yeah.
Yeah.
That's exactly what it is. Now, did anybody think about that comma, that it was going to be there?
Right.
No, but it's there. And again, for very technical documents on you get in there, those commas can make the difference, or a semicolon, right? I mean, they can make the
I know it sounds crazy, but it is what it is.
Well, and I mean, I've had a couple of cases in the last month where there was a period. And you're going, if they would have just made a compound sentence, I think we would have been okay. But nope, they put a period there. Those are two distinct, concepts. And again, we kind of nerd out on stuff.
Yeah.
But it really is, I mean, for me, I mean, we have several people that they find out after the fact that there was something that was there, and having the right contract. I'm sure it's the same thing for you. You feel good that you've just said, look, the risk was low, for this, but we have recourse to this. And it makes all the difference, for people when they have the recourse.
Yeah. And what a lot of people don't realize is, whether the business is small and simple or really large and really complicated, the allocation of risk issues in many ways are still a lot the same.
That's right.
And so, being able to address the more detail you put in the document, the more you address things, the more you lower your risk, right? So, talking about the thousands of pages, right?
Right.
When you've got a massive deal where everybody's willing to spend the money because they want to know where the risk is going to be allocated, you're able to line out in way more detail, right? In those contract provisions. Whereas if you do a 15-pager, right, you're committing 3 sentences to an issue that says, hey, look, this is basically how we're going to deal with this,
right? As
opposed to 3 pages to deal with the issue, right?
I have those conversations with people like, hey, we're going to keep this simple because we can make this.
Well, a lot of them are like, well, hey, do you have like a form purchase agreement that you could pull off, right? And it's like, people don't understand.
Oh no, Jeff, I have people tell me they're bringing me one they got off the internet.
Yeah.
And I just look at it and do it.
Right.
If it's somebody watching this, I'm sorry. No, I mean, because again, the technical aspects of that,
right,
to make sure that we as lawyers can tell them that there is value there. What's interesting, and again, in the lower middle market, I know you don't see that much, is when you buy a house. I always tell people this.
Yep.
When you buy a house, the paperwork, when you have to go sign and you walk away from closing, you got that much paperwork that comes with you. We don't think much about that, right? We're like, okay, well, sign. That deed of trust, sign. That is not what M&A is for a business. And, you know, when you kind of talk through it with people, a house is a static, you know, it's got, you know, the plat, it's got the deeds, we can go look at it. It's very static in time. Whereas the business literally is moving all the time, all day, every day. In fact, even when you sign a contract, it's still moving, which is why you have to figure out what happens if something breaks in that machine. And because of that complexity, you have to, it's something you just can't print one off.
Well, and that's, I mean, it's a good point, right? With the real estate transaction like that, where you're selling like a residential home, you had all the major players in the industry get together and say, hey, we're just all going to agree. Then when we do this kind of deal, which is very repetitive, and is, you know, property in a building, property in a building. We're going to use these forms.
That's right.
So they're set. Now you tweak the forms and there's options and things that you can do to add and to detract from the forms, but the baseline is set there, right? M&A, that doesn't exist because no two deals are alike.
Right. No two companies are alike.
No
Even
two
in the same
companies
industry that do the same product, they're still different.
So there's no way you can do that. Now, if I'm a serial acquirer, right? Like if my growth strategy, if I've had a business for a while and my growth strategy is to grow through M&A, then I can often, and I'm in the industry, I can often develop an internal purchase agreement form that I'm comfortable with because I'm doing the deals over and over again and I've seen the risks on my side. I know what's kind of bitten me in the past. So you'll sometimes see, you know, like a strategic or serial acquirer that will have, quote unquote, a form that they start with. But even that gets massively negotiated once they actually get into the deal transaction.
Oh yeah. I mean, it's no lie, right? We're, as lawyers, transactional lawyers, we use forms, but except for maybe a single member LLC, right? I've never done the same deal twice.
Yeah, they're all malleable.
Even when there's more than one owner on there, they may be kind of close and maybe 95, but most of the time, no, 75% of it's the same on there, but that 25% makes all the difference to that transaction. And M&A, that could be even, you know, different. That could be 50% of it is similar, but the other 50% made it all the same. You know, for all those using ChatGPT and LegalZoom, watch out because they don't know that stuff.
Yeah, that's the worst when I have a client comes to me and says, "Oh, I just did these forms myself, or I pulled them off of LegalZoom, or I, you know, ChatGPT or AI or what, you know, whatever." And then now they want to sell the company, right? This goes back to the conversation we had earlier about somebody, you know, prepping stuff. I get those docs and I'm like, "What in the world did you do?" And then having to like clean it all up and fix it.
Jeff, on the formation side stuff, I have seen some things that even when you Google goes, I don't know what you're talking about.
I bet.
You know, again, so there's a value there. I mean, there's a cost. And, you know, this is another thing that you actually taught me on this was as lawyers, we have a bad reputation as lawyers, the industry, right, of being sharks. And, you know, the old joke of, you know, the lawyer dies and he goes up to heaven and, you know, St. Peter's there. And he's like, you know, wait a minute, you know, you're only 50, 60 years old. Based upon your billable time, you should be 150 or something.
Yeah.
But you said this a lot, and I say this to my clients a lot too. I'm gonna give you complete credit for this is, are we providing value as a lawyer? Because that's ultimately what we have to do. It's not really about our rate. It's about what the client is and the value that we provide to be able to get that. And it's important that, you know, people that are trying to buy or sell businesses, they go find lawyers that will give them the value. And it could be, you know, $1,000 and that's the value you need. Could be 100,000, you know, or more dollars, but that's the value you need. And finding that is super important. Too many times people miss that.
Well, and that's one of the struggles as, you know, and I identified this when I was a young associate, when I realized, wow, it's, you know, it's hard to educate clients on the value that we bring, right? Because they haven't had the legal education. They don't understand how you can take one provision and write it 12 different ways, right? One that swings extremely pro seller and the all the way in the other direction, which is, you know, extremely pro buyer. And, you know, when I was younger and I would get sick, right, I'd be like, oh, I just need to go to a doctor because doctors heal people.
Right.
A lot of people think, well, I'll just go to a lawyer because a lawyer knows the law.
Lawyer's a lawyer, right.
Not the case, right? Not all doctors are created equal. Not all lawyers are created equal.
Right.
I would never go to a litigator to do a transactional, nor would I expect a transactional attorney to litigate anything. But even within, you know, those frameworks, right? There are transactional lawyers who have more experience, education, et cetera, than others. So they're not all created equal, but yeah, you're absolutely right. It's about creating value for the client, helping the client understand the value.
Right.
And, you know, also knowing when to argue and when not to argue.
I mean, just as a basic example here, confidentiality agreements, we've mentioned this before.
Yep.
People think those are all the same.
Yeah, and they're not. There's been whole books written on.
Right. And, I mean, I've looked at clients' confidentiality agreements in a transaction and go, do you realize in 1 year they can actually take everything that you just showed them and use it? Like it terms, the whole thing terms.
Yeah.
There's no ongoing, on that. I was like, how long you been talking to them? Oh, about 10 months.
Well,
I'm like, well, they may not be around in 3 more months too. That, oh, well, I thought all non-disclosure agreements were the same. I mean, it's the details that matter.
Well, and on a transaction on a client not to be named, there was a buyer or investor, I should say. There was an investor that was interested in a company, and they had, part of their due diligence request list was, hey, we want to see all your employee, invention assignment agreements, et cetera, to make sure that the company owns all of its intellectual property, et cetera.
Right.
And we had only been recently engaged because it was a smaller startup company. They were trying to do a lot on the cheap.
Mm-hmm.
And so they had used some outside service not to be named to help them.
Right.
And so when the request came over to us, hey, can you help us prepare the data room, right? To put in a data room is just a room where you put in information, copies of contracts, financial information, et cetera, that an investor or a prospective buyer can go in and look at to decide whether or not.
Sophisticated Dropbox.
Right. Exactly. Sophisticated Dropbox. That's a great way to put it. To see if they want to do the deal, right? Whether they want to invest or whether they want to buy. So anyway, they said, hey, Jeff, can you put this information in there? And don't worry, this other group that we've worked with, they're going to drop in these, NDAs. And so I was waiting for it, and the NDA that I received was a half-page NDA that wasn't even between the company and the employees.
Oh, no.
It was an NDA for hey, we'd like to explore doing a transaction together.
Oh no.
So they didn't even.
There's a potential transaction.
They didn't even have the right form of NDA. Turned out they didn't have anything signed for any of their people. So we had to go back and create something. So yeah, not all confidentiality agreements.
Yeah. And again, I mean, you make another point because that costs that client more money because it's an issue. No buyer's going to buy that when they can't, say I got all the IP. So then it's, well, now you got to get everybody to re-sign it. And you can have one person that holds out on you and messes up your entire transaction for that. So yeah, again, the value of finding the right, attorney with the right experience, I can't stress that enough. Let's talk about the annual Outlook survey here for Dykema. It's fascinating to me, where we are in our economy right now. We're in a transition period. The election happening here. We're taping this. It's supposed to happen. It is supposed to happen. It will happen on next Tuesday. But there's a lot of dynamics in our changing economy that's going on in there. Tell me a little bit about why, what's the importance of this? Because there's some really interesting outcomes that came out of it.
Yeah. So the surveys, it's something we've done every year for 20 years now. And our clients really enjoy it, as do many of the, other folks we work with, referral sources and others. So what we do is we go out and we survey those who are in the deal-making space, right? CEOs, CFOs, accountants, investment bankers, other attorneys, C-suite folks, and all across the country, multiple industries, to say, hey, how are you reading the tea leaves, so to speak, right? Like, what is the next 12 months do you think going to look like in the M&A space? And we, based upon trends and other things that we see in our own practice, we sometimes tailor the questions to, get insights into what people are thinking. Where's the M&A deal activity going? Is it going to be, lower market, middle market, upper market? Is it going to be, what industries, sectors are going to be most effective? What are the headwinds? What are the things that seem like they're helping to drive M&A? And so all of that is in the survey, which is on Dykema.com if people want to go look at it in more detail. But so that's at the outset what we do, right? We gather all that information and then we put it together and then we send it back out to not only the folks who participate in the survey, but our clients and others who we think are interested in the space, right? So this year, what was interesting about this year is it feels like, those who have been in M&A know 24 was, I don't want to say it was a down year, but it was definitely slower than it has been. I mean, we came off some gangbuster years just a couple of years back. And you know, there are lots of reasons for why it's slowed down, or people think it's slowed down, right? Well, some general economic concern. We had high inflation, we had high interest rates. So there was just a lot of uncertainty out there. A lot of those concerns are dialing back. I'm not going to say inflation's under control, but it's getting better, right? Interest rates have come down a little bit. I know people would love to see them come down more. We'll see. Inflation's been kind of stubborn, right? But when interest rates come down low, that allows, you know, strategics and others out there who might want to leverage up to do a deal, gives them some more flexibility, helps valuations, right, for companies, helps people come, you know, to a better agreement on valuations anyway. So there are lots of indicators that are pointing to a very positive 2025.
Yeah, I mean,
M&A, and we're excited about it.
70% expect, you know, growth, which, you know, which is great news. I mean, that's another reason why I was really excited to have you on here, is because we focus on the stock market. You know, going up, and we were laughing beforehand. I mean, you know, how much of that is the bots that are bullish? How much of that is the economy, right? But I mean, the stock market has been roaring, but with the deal flow not going at, you know, gangbusters, because when it goes at gangbusters, that's really our highest points of true growth. You know, that we see is when M&A is hot and going.
Yeah, when consumers are happy.
The booms happen when M&A is happening, you know, on there. So to see that that's going, that's very, you know, reassuring, you know, for the economy as well.
Yeah. When the economy's down, the only deals you're looking at are, you know, deals out of bankruptcy, unfortunately. And things like that. So,
which I was in there in 2008 because you could go find the deals during that time and learned a lot. One of the interesting things that I saw in here as well was the industries that were looking at growth. I mean, not everybody, but a lot of people know about private equity. Private equity in the last decade has been at the forefront of conversations, even all the way down to the mom and pops, based upon roll-ups and healthcare. I mean, home services, we're seeing roll-ups right now, some not so successful, but nonetheless, people trying to roll those up. Private equity is going to be strong, but, you know, it's not actually the top one that, you know, industry that you're seeing that growth. It's healthcare, which again was kind of taken aback on there. So what were some of the other things that, you know, from the survey that, you know, you think are things that were surprising to you?
Surprising? I don't know if there was anything necessarily surprising. I mean, I might have been a little bit surprised by how optimistic folks were over the next, you know, for 2025. I don't know if that's because folks are really hoping for or betting on further interest rate cuts or not. And this is my own personal opinion, right? I still think inflation is going to be a little bit more of a pernicious bug than folks have thought about, but we'll see. I hope I'm wrong. But yeah, private equity has been and will continue to be a major player in the M&A space, right? And in all sorts of industries. Healthcare in particular, and I guess that maybe surprised me a little bit, only because not only are we seeing a tremendous amount of interest and deal flow in the healthcare space, right? Lots of consolidations by private equity, whether it's, you know, DSOs or MSOs or VSOs or, you know, whatever the case may be. But we're also seeing interest from the Department of Justice and the Federal Trade Commission, right? Who are saying, hey, we're concerned about how much consolidation is taking place in the healthcare space. So while there's a lot of excitement and energy that's still in that sector from the deal maker's point of view, we're starting to see some headwinds coming the other way from regulatory authorities and others. You know, everybody knows the price of healthcare care has been going way up.
Price of vet services are going up.
Yeah, whether or not that's all, you know, I would say there's a 1-to-1 correlation with private equity, right? Obviously, there's lots of things that are causing that.
Sure.
But it's caused some concern out there, right? So we'll see what happens. Financial services industries is another one that's, you know, people have talked about for years. They thought there was going to be more energy and consolidation in that space. Speaking of energy itself as a sector, looks like it's going to be another one that's going to pick back up again. So, it should be an exciting 2025.
You know, it's interesting on the healthcare and some of the other, you know, roll-ups that we see in professional services, right? With the private equity. Because of that, you know, scrutiny and that regulatory concerns, from an M&A standpoint, I mean, if you build it all together and then have to break it all apart again, right? There's still M&A on there. And it's, you know, I mean, healthcare, we have seen a wave. I think this one's a more permanent wave because of where we are.
Yeah.
I wasn't there for the wave in the 80s when there was consolidation of healthcare and all those sort of things. But then they broke them all apart after that. You know, I don't know that we're going to see that in healthcare, I think, for many things. But in other roll-ups that are out there, I mean, you could also see eventually with that scrutiny, strategic breaking off.
That's often true, right? That's what makes the deal world so much fun is there's the constant ebb and flow, right? There's always something new, something exciting going on, some new technology, some new sector, right? So
speaking of new, let's kind of end with this because there was AI in here.
Yes.
And everybody wants to talk about AI. From like, you know, again, we're lower middle market. So, I mean, we have a lot of startups that are, you know, building AI tools and that sort of stuff. What do you see for AI, you know, for the markets that you guys are serving at Dykema?
Well, there's no question that it's continuing. I mean, I don't want to say it's the driver, but it is certainly a driver in a lot of what's going on out there for multiple reasons. For some companies, it's all about efficiency, right? And technology, and AI is able to help them drive greater efficiencies in what they're doing in some sectors. In the legal space, right, AI has greatly facilitated the due diligence process. Now, it hasn't replaced, you know, the lawyers who need to go back and verify the information and the data, but it provides an added layer of security. In terms of the diligence process, right? When you can just drop a bunch of documents, for example, into a software program that does the initial analysis and says, hey, here's, you know, what we've kind of flagged as potential concerns or issues that, you know, somebody should go back and look at. Right? Then we can use that as a baseline. Doesn't mean we rely on it entirely because you can't yet. You can't rely on AI to do your job for you. But it's a tool that has, you know, vastly improved the diligence process.
The old model, just so you know, was Jeff would walk into my office with the boxes and then drop it down and then say, start getting this.
Matt, get me these 700 contracts reviewed by morning and get me a memo on each one.
I need to know all of the assignment clauses that are in there, termination provisions.
Change of control.
We'll see you in a week. See if you can get an hour of sleep during that. No, I'm kidding. Not kidding on the hour of sleep and that sort of stuff. But that was the old way. Was a lot of that. And again, AI as a tool right now, at least is a supportive tool.
It can jumpstart that process. Exactly.
It doesn't replace it.
No, it doesn't. But it can jumpstart the process. It can facilitate it. So
I mean, yeah.
On the legal side, that's one of the exciting things about it. But I mean, you're starting to see AI creep its way into, of course, really where the rubber meets the road. I think for the AI advancements right now is you're starting to see it risk analysis for investment bankers. You're also starting to see it in connection with consumer end facing experiences, right? And all of that drives, in my mind, to the bottom line of efficiency, right? Which is where everybody's the most excited to see, like, how can we capture AI in a way that it improves our efficiency, improves our profitability, improves our output to the end consumer customer.
And I would assume because of that, larger organizations, right, will look to acquire the startups, the small companies, because they're more agile and they don't need to take that risk. Let the small, you know, businesses take the risk on developing these, and once they show the promise, they'll do. I mean, the iPhone that we've got, I mean, probably half of the features that are in it, Apple didn't do themselves. They acquired somebody that had that technology.
It's like any other, you know, improvement in the M&A space, right? You have those who have the money who don't have the, whether it's technology or the process or the patent or, you know, whatever it is that they need. And then you have those who have the patent or the process or the technology, but they don't have the wherewithal to make it happen. And so that's what the transactional space is all about, whether it's, you know, investments through private or public offerings, or whether it's through M&A space. It's bringing those people together in a deal who want to do something because they each have something that they know the other wants to make something better happen, right? That's what it's all about.
Well, Jeff, I can't thank you enough for coming on. This, again, for those, we'll have the link. You can find it there in whichever platform you're watching to the Outlook survey so they can take a look at that. But thank you for coming on and talk about this. I love nerding out about transaction stuff. I mean, it is fun. It's fun to be a part of all these type of deals because at the end of the day, I always tell people transactional work is different than litigation in a big way because when we get to the end, usually everybody's happy.
Should be.
You know, it's not always the case, but the odds in litigators, somebody, if not both parties, are not happy at the end of, the day for those, so it's an exciting thing to be a part of. And again, thank you for your mentorship and coming in here.
No, thank you, Matt. I mean, it's been a lot of fun. It's always great to be with you. I always appreciate our time together, and you got a great thing going here. And so it's been fun. Thank you.
Great. Thanks so much. I hope you enjoyed that episode as much as I did, getting to talk to my mentor, Jeff, about all things M&A. Here at the South Texas Business Lawyers, we do a lot of acquisitions and divestitures with small and medium-sized business. And this episode, I think, was informative for everyone on the do's and don'ts and even some of the basics of M&A that we educate our clients on a daily basis for those that are new to it. Here at the South Texas Business Lawyers, our mission is to educate, support, and advise every small and medium-sized business here in South Texas, and we support our startup community here. And we hope that this has added value. If it has, click the subscribe button, leave us a comment, and make sure you don't miss the next episode of the South Texas Power Lunch. Have a good day.